This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today it's time to talk about exclusions, especially those in an errors and omissions policy that was used in an attempt to find coverage for defense and indemnity to a wrongful death suit brought by the spouse of an injured worker. To compel coverage under an errors and omissions policy, Roadway Services, Inc. sued its insurer Travelers, Casualty and Surety Company of America, seeking defense of a wrongful death case arising and claiming that Roadway failed to provide a safe place to work for the decedent. Travelers argued it had no duty to cover Roadway's claims because of a clear and unambiguous exclusion. In Roadway versus Travelers, a December 29, 2022 decision of the Sixth Circuit Court of Appeals, the Sixth Circuit resolved the dispute and dealt with the following facts. In 2018, a driver struck and killed a Roadway employee while he was on the job. His widow sued Roadway for wrongful death, alleging it failed to maintain safe working conditions. Roadway did not seek coverage under its employment-liability insurance contract. Instead, it asked Travelers to pay for its defense out of a director's and officer's insurance contract. Both parties moved for summary judgment, and the district court, finding the policy ambiguous, ruled for Roadway. Travelers, of course, appealed. Under Ohio law, an insurance policy is generally interpreted like any other contract, and specific provisions always govern over more general ones. Roadway's policy covered Roadway's directors and officers as well as the cost of indemnifying them, and Roadway itself. It insured Roadway for losses resulting from any claim made during the policy period. However, the policy also contained a relevant exclusion, Exclusion A.13 D, provided that, quote, with respect to insuring agreement C only, Travelers will not be liable for loss for any claim based upon or arising out of any employment-related wrongful act. In analyzing the policy, the court noted that the employment-related wrongful act exclusion barred Roadway's claim since the wrongful death suit involved what the parties agreed qualified as an employment-related wrongful act: Roadway's alleged failure to maintain safe working conditions. Exclusion A.13 D clearly and unambiguously eliminated coverage of Roadway's losses from the wrongful death suit. Roadway's arguments otherwise were not convincing. Because of Roadway's alleged failure to maintain safe working conditions, its employee would not have died, and his widow would not have suffered mental anguish and sued. Thus, the losses arose out of Roadway's wrongful act, and the exclusion applies. A claim can both arise out of a wrongful act and be a claim for injury brought with respect to the act. Nothing in the contract of insurance suggested that the drafters intended to give the terms anything but their plain meaning, even if the meanings included some overlap. The Sixth Circuit concluded that no conflict existed between the two exclusions, one of which Roadway claimed eliminated the effectiveness of the other. The Sixth Circuit concluded that there was no conflict between the two exclusions, nor were the exclusions ambiguous. The district court's judgment was therefore reversed, and the case was remanded with instructions to enter judgment for Travelers on the coverage claim. In my opinion, when an employee dies on the job, the exclusive remedy available to the heirs is the workers' compensation system, which does not allow or require a finding of responsibility, only a finding that the employee was injured on the job. To gain a larger recovery using the tort system, the decedent's spouse filed a wrongful death action claiming the employer was negligent for failing to provide the decedent with a safe place to work. Roadway had employer's liability insurance but chose to claim against an E&O policy, only to find that a clear and unambiguous exclusion defeated their claim. Why they didn't require the plaintiff's spouse to be limited to workers' compensation is hard to understand. Roadway sought coverage, on the other hand, under a policy not designed to cover a wrongful death claim by an employee. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can also subscribe to the blog post, and you will receive an email advising you of the daily blog postings, now reaching over 4,400 blog posts. There are also videos on rumble.com with almost 600 videos and youtube.com with more, all of which are free to anyone who clicks on the various links which are available on the blog. And you can subscribe to the videos, and if you do, I'd appreciate it if you click on the like button or the Rumble button, depending on which service you use. And if you found the videos and the blog postings to be useful to your colleagues and friends, please tell them about it so that they too can subscribe to the videos and to the blog post. Thank you for your attention.